Otherwise, maybe we'll look to hear from you before then.
Thank you, Judge.
Have a good day.
You as well. You would be excused?
Yes, sir.
Thank you.
What's next?
Second on page 1, Judge.
Mhm.
In cause number 2021 DCV 2367, Donna Moore versus Laura Macias and Guadalupe de la O. Announcement of counsel, please.
Marisa Parros on behalf of the plaintiff Donna Moore.
Good morning, Your Honor. Jessica Mendez on behalf of the cross plaintiffs, Guadalupe de la O.
John Dickey for defendant.
Good morning. Entry of judgment. How are we doing on this one?
Yes, Judge, our client lives actually out of town, and we're having her sign the release. As soon as we do that, we'll be able to get payment and we'll submit the dismissal documents to the court.
Any reason I can't also go to that January 31st reset, or is there something else pending?
No, Your Honor,
I think that
there's a health insurance lien on my end that's holding up the payment for our clients, but I think January 31st will work. I'm sorry, John.
That should work, yeah.
I thought I heard you say yes, Mr. Dickey, so I'm going to reset you all for January 31st.
That's fine, Judge. Thank you.
Thank you so much, Judge.
Thank you for your time. Y'all take care.
Thank
Thank
you.
you.
Too.
Okay, next.
Staying on page 1, Judge. In cause number 2022 DCV 2486, Terry Finkley versus Pay and Save Inc. et al. Announcement of counsel, please.
Eugene Kim for defendant EP Samana, Your Honor.
Hugh Lyle here for the defendant, Pay and Save Inc.
Good morning, Your Honor. Daniela Labinotti for the plaintiff.
Good morning, counsel. Final judges conference. That's the only thing we have today.
Yes, Your Honor.
How are we doing on this one?
Well, we have been working hard. The week before Thanksgiving, we heard some expert depot that I think we lost weight from the whole day deposition of or maybe not lost weight. Maybe went home and had some drinks afterwards because they were. We got a 15-minute break, I think. But anyway, we've been working hard, Judge. We've had expert deposition. We've had depositions. We've had a lot of work in this case. So we are set for mediation with Judge Villa. So I hope Judge Villa does a miracle on December 8th.
Oh, sorry. I didn't mean to do that. I didn't mean to do that so loud. Let me ask you,
I know, Judge.
When are you set for mediation?
We are set for mediation on December 8th, I believe.
Oh, wow. Okay.
No, is it correct, Lyle? You're gonna. I think it's December. Did I say it correctly? Or no? Is it? Let me.
Yeah, that's the date. That's the date that we have to have our mediation statement. Is the 19th.
Oh, it's the 19th. Okay, I have another one with V on the 8th, but it's not
19th of December.
Yeah.
No. Yes, 19th of December, Judge. Correct.
Holiday miracles. I believe in them. But in case there isn't, we will see you on January 10th for the final civil pretrial. I'm not going to ask the question of how it looks for trial until then. So we'll see what happens.
Well, Judge, I think you need to pray for this one.
I pray every day. You all are set for January 10th, 2024, but obviously I'm going to be checking in with you all, and we'll probably hear from you all if it's actually going to go, because we're set early on in the year. And I know there are some holidays leading up to that date. So I haven't looked that far ahead in terms of the court's trial docket. I just want to know, I will want to know at that point, if you're still in the mix, but we'll see. Good luck, guys. Anything else, Mr. Lyle, Mr. Kim?
No, Your Honor.
I'm laughing because poor Mr. Kim has been having heart attacks, minor heart attacks throughout the proceedings of depositions in this case because of you, Lyle, and I'm afraid that if this case goes to trial, we're going to need some EMS services outside ready for us, because this has been a very intense case for all of us. So I hope for all of us, especially for Mr. Kim, that
we'll make a note of that. Thanks for the heads up, Mr. Kim.
Yes,
everybody. Take care, okay? No heart attacks, please.
No heart attacks. All right. Bye, everyone.
Thanks, Judge.
May we be excused, Your Honor?
You may have a good day.
Thank you.
Who's next?
Third one on page 2, Judge. In cause number 22 DCV 0577, Katie Jo Munoz versus Timothy Eugene Myers. Announcement of council, please.
Good morning, Judge. Cal Mundell for plaintiff.
Good morning.
Judge, I don't see defense counsel on, but I have good news. The case settled at mediation.
So that's good. You can be the bearer of good news. Let me see. So we just need to get this. Hold on to make sure I'm looking at the right one. I am not. We'll get you reset what? You need 60 days, 90
perfect,
days,
Judge.
60 days of work?
60 will work.
Okay, we'll get you set. Thank you for appearing.
Thank you, Judge. Have a good day.
Thanks. Bye-bye. Who's next?
Towards the bottom of page 2, Judge. In cause number 2023 DCV 0224, Wilma Yarbrough versus the State of Texas. Announcement of council, please.
Claudio Flores for the defendant, Antonio Ventura, ready, Your Honor?
And I do see Miss Yarbrough. Can you hear us?
Yes, ma'am. Can you hear me okay?
Yes, I can hear you. Bear with me just a second so I can pull your case up.
Yes,
We are scheduled for a final status conference. It looks like we did get that discovery order back in.
yes, ma'am.
So how are we doing? I don't know. I felt like Mr. Flores, I thought there was something you were going to be filing that required a hearing. I don't see anything. How are we doing here?
Your Honor, Ms. Yarbrough has failed to join all necessary parties. I have not filed a motion to dismiss, but I will file that today, Your Honor, and ask for a hearing on that.
Ms. Yarbrough, I don't see that anything has really changed just in terms of the entries on the court file, the electronic court file. So we are coming back on January 10th at 10 a.m. It is going to be via Zoom. Unless I hear something different from you all requesting another setting, we'll see you then.
Thank you, Your Honor.
Your Honor, I wanted to mention to you that this place, I'm gonna get an attorney. I just gotta come up with this is my case worker, Mary Hardesty. She's helping me because I can hardly talk. And I want to see if it's possible that Mr. Antonio Ventura can pay me 1/10 of what he owes me instead of trying to dismiss it, because I'm going to continue providing it until I get my portion of it. As far
So
as
if you're, Ms. Yarbrough, if you're looking, Ms. Yarbrough, if you're looking for some type of settlement negotiation, you have also mentioned you are going to hire an attorney. I don't know if that is going to happen, if your attorney will be engaging with Mr. Flores in terms of some negotiations. If you do not, then obviously, if you have a proposal for Mr. Flores, you all need to communicate that. What I am telling you is that you have your final civil pretrial on January 10th. If you have an update, if you end up hiring an attorney and they need to file an entry of appearance, so Mr. Flores and the court can be aware that you now have an attorney. If not, we'll reconvene. We'll meet again on January 10th, okay?
Yes, ma'am. Thank you very much.
Take care, Ms. Yarbrough. You be safe.
Yes,
Thank you,
ma'am.
Mr. Flores.
Thank
If
you,
you
Your Honor.
need a
Thank
hearing
you.
on
Merry
something,
Christmas.
same to you. If you need a hearing on something, if something is filed that requires a hearing, please notify the court coordinator so we can get it scheduled, okay?
Yes, ma'am, Your Honor. Thank you.
Thank you for your time.
I don't.
Can she actually get Mr. Flores' number, because I know what he mentioned to her and she hasn't mentioned any of that to me. I'm just her caseworker, so I'm just helping her through it for a better understanding.
Mr. Flores, could you please, Ms. Yarbrough, are you still accessing your email?
Yes, but I have a different phone and I have a different email now. It's
If each of you will contact Ms.
Okay.
Hernandez, the court coordinator,
Yes, ma'am.
And she will help facilitate you all sharing your contact information, your updated contact information, okay?
Wonderful. Yes, ma'am.
Is there a
Thank you.
number for, you have the number for Hernandez, right?
Okay, I got her number. I don't have Mr. Flores'
No,
number.
no, we're gonna get with the
The court coordinator.
coordinator
with her,
Hernandez,
okay.
okay.
Yes,
Okay.
I want to make sure everything is confirmed that you all have exchanged information. And I don't know how well we can do that over Zoom, okay?
No, no, I understand that, okay.
Okay. Yes, ma'am.
Okay, you have their number, the court coordinators?
Can you give it to me just in case, please?
It's the court phone number is 546-2130.
Yeah, that's it.
Thank you very much, Judge.
Thank you for your time. You all be safe.
Happy New Year.
Christmas, okay.
Thank you.
Can we be dismissed?
Yes, ma'am, you all are excused.
Thank you.
Okay, who's next?
Judge, bottom of page 4,
Mm-hmm.
in cause number 2022 DCV 2118, Maria Cristina Cerrato versus the Toro Company. Announcement of counsel, please.
Kayla Miller on behalf of the defendant. I don't know if the plaintiff is here. She's pro se at this point.
Okay, Maria Cristina Cerrato. Is there anybody in the waiting room, Mr. Marufo?
No, Judge.
Have we received any contacts from plaintiff?
I haven't, Judge.
Let me see. Where did we send notice of this hearing? Oh, is this the one that Miss Judy withdrew?
Yes. We were giving the plaintiff some time to get a new lawyer.
Mm-hmm. So, Ms. Hernandez, Mr. Marufo, we haven't received any phone, emails, anything like that?
No, Judge, and I didn't find an email address for Miss Maria Cristina.
Let me see, where's the clerk? Mr. Medina, are you seeing notice? It looks like the order setting hearing was back on October 30th. I have an email there. It looks like on the notice, christinecerrato@gmail.com. Was that sent to that email? And can you tell me if it was opened?
Hi, Judge. For Cristina Maria Cerrato, it says it was not opened.
I'm going to set this for dismissal, Ms. Miller, in 2 weeks. I need to go back and look at that hearing because if I remember correctly, I think we discussed this exact date and she was told of the exact date at that time.
I believe so. And to either end, this case is barred by workers' comp. So we have a summary judgment ready to file as well. So
okay.
Well, we're happy to come back in 2 weeks.
Had you requested your hearing on the summary judgment?
No, not yet.
Okay. So this is, and you served Ms. Cerrato at the email with that motion?
No, we haven't filed it yet. We just have it ready. We were waiting for this hearing to take place to see if she had new lawyers, give her the opportunity to get new lawyers.
Okay, so as of today, she failed to appear but did not open the notice. I'm going to review the last hearing that we had, and I'm going to set this for DWAP in 2 weeks.
Okay.
Okay.
Great. Thank you so much.
Thank you for your time.
Have a great day.
You too. Who's next?
Going back to page 2, Judge, middle of page 2. In cause number 2021 DCV 3473, Yarihira Vasquez versus Gabriele Ruiz. Announcement on counsel, please.
Good morning, Your Honor. Gabriel Perez on behalf of the plaintiff.
Good morning, Your Honor. Joe Garcia on behalf of Gabriela Ruiz, the defendant.
Are we still needing to set this for, was it a bench trial? I don't remember. No, it wasn't a bench trial. It was a 1 day, we had a jury panel in the middle of the week trial.
Correct.
That's correct, Judge.
Have you all looked at a date?
Probably after January, Your Honor. I have 2 or 3 in January already set, so maybe February or March of next year.
Okay. If memory serves, we had it set on a Wednesday. Myrna, can you look at the February 2024 calendar and see if we can, let me ask counsel this. Are there any dates that you know you are unavailable?
I do have some in January.
February.
February. Well, I do have trials almost every week, Judge, but I mean, that can be worked around.
I'm thinking February 21st. Myrna, if you can look at that. It's either gonna be the 14th, so everyone can wear red, or the 21st, you can wear whatever you want. And I will secure a small panel that we can get this taken care of, within a couple of days. I just need to verify what the regular trial docket looks like.
And Judge, the 14th is the one that works for me. The other 2 weeks, I actually have a trial each week in another courts as well. So if we could do the 14th, that would work best. Okay,
so potential 14 backup, maybe the 7th. So I'll look at those and we'll get you a setting either way. Okay.
Sounds good. Thank you, Judge.
Anticipate whatever trial date we end up with. There will be a docket call the week before that, just to check in with you all. Okay.
Sounds great.
Thank you for your time. Have a
Thank you,
good
Judge.
day.
You too.
You may have a good day.
Bye.
Thank you, Judge.
Judge, bottom of page 2,
Mm-hmm.
in cause number 2023 DCV 1828, Emma Alcantar versus Alejandro de la Cruz et al. Announcement of counsel, please.
Good morning, Your Honor. Daniela Dabinalti for the plaintiff.
Good morning, Judge. This is Steve Blanco on behalf of the Kenny 2 Independent School District defendant.
Your Honor, good morning. Blake Downey on behalf of Alejandro de la Cruz.
Okay, scheduling status conference. Are you all, you want your trial date? You want to get your scheduling order into the court? Are you all ready for that?
Yes, we're actually in the middle of written discovery, so we'd ask just to get a trial date so we can work backwards into a scheduling order.
Let me ask, I would be putting you probably, let me look. When was this actually filed? I'm normally a year out, so that would put us in November of 2024. Is that workable, not workable?
We can try for the date, Your Honor. This was filed on June 7, 2023. So it is a fairly new case.
Okay. Are you all comfortable with a November 2024 trial setting?
Yes.
We'll do November.
First 2 weeks of November, if possible, Your Honor.
Yes, I'm looking at November 1st. So that puts your docket call at October 30th. Your final civil pretrial will be approximately a month before that with that mediation deadline. Please make an agreement on the mediator you all intend to use, and we'll get you a scheduling order, return it. You don't have to appear for entry of the scheduling order, okay?
Yes, Judge.
Thank you very much. You'll have a good day.
Thank you.
Thanks, Your Honor. Bye, everyone.
Bye-bye. Who's next?
Judge, I believe we have everybody on page 4, top of page 4.
Go ahead.
In cause number 2021 DCV 3028, Rosa Maria Saucedo de Alonso et al. Versus Fifth Floor Freight LLC et al. Announcement of counsel, please.
This is Matt Greenberg for the Alonso plaintiff.
Good morning, Judge. Randy Ordonis on behalf of defendant F&F Construction. It's my special exceptions.
Good morning, Your Honor. Stuart Forbes on behalf of Edith Erickson and Daniel Huerta, and Mrs. Forbes on behalf of Bertha Ortiz.
Good morning, Your Honor. Norman Snyder for Fifth Floor Freight LLC.
Good
morning, Your Honor. Or go ahead.
Go ahead, Ms. Horn.
Thank you, Your Honor. Here on behalf of the Detmar entities.
Your Honor, here on behalf of J.A. Alonso Trucking LLC and Rosa Maria Alonso as representative of the state of Jose Alonso.
And that is Mr. Vereen. Okay.
Yes, Your Honor.
Mr. Benya, you're still outstanding.
Yes, just waiting. Nick Benya, here on behalf of Claudia Guzman.
Is that everybody? I'm trying to look at all the Brady Bunch boxes here. Okay. All righty, Mr. Ordonez. Let me make sure it says, are we only here for this? Okay. All right, Mr. Ordonez, go right ahead.
Judge, if you may recall, we had set a special exception hearing about 45 days ago. At that time, you allowed the plaintiffs and counter plaintiffs to amend their petitions to allege any facts or causes of action against my client, because at that time there were none in their pleadings. In the moments leading up to this hearing, they did file amended pleadings, and in my brief skim over them, from what I can tell, they contain.
Mr. Ordonez, let me just stop you quickly so that I don't get lost in the entries here. Are we talking about the amended? What is the date of the pleading? The amended?
It would have been filed today. They were filed in the moments leading up today. I believe it's their 5th.
Okay, I'm going to ask the clerk if you will go through. I want to make sure I'm looking at the right case. I don't see anything filed as of October, actually November 3rd. Okay, go ahead, Mr. Ordonez.
So the filing did come through on my end. It came through, like I said, in the moments before this hearing. And so I've briefly been able to go through them. But from what I can tell, the pleadings do not meet the fair notice standard, as they just contain conclusory allegations. Now, they were able to serve my clients with discovery, which we responded to. But again, their pleadings are just conclusory in nature and have no facts to support any sort of cause of action against us, merely conclusions. And so again, we would ask that the court now exclude us from this case.
All right. Well, I'm a little bit I was trying to check the email as well. Myrna, did we receive an email copy, like a courtesy copy? Because it's not in Odyssey. I don't have a document. Okay, who's going to respond? Mr. Greenberg?
Yes, Your Honor, I did file an amended petition this morning. I'm happy to share it on my screen. I do believe that the filing went through. We did receive a lot of discovery a week or two ago from F&F Construction. It was substantial. We reviewed it and internally, and I think we put defendant on fair notice of what we claim is the cause of action. It's negligence, that they had a duty to provide and do the work in the manner befitting a company of ordinary prudence. We allege that they had a traffic control plan that was issued by the state of Texas. They produced a traffic control plan, and our allegation is based on the evidence that there was a deviation from the traffic control plan that allows the plaintiff to sue F&F Construction for negligence. We've also have videographic evidence that I allude to, but I didn't include a screenshot, but there's videographic evidence from the Ector County Sheriff's Office showing that an F&F Construction individual bearing the F&F Construction safety vest and insignia on the vest, and I think maybe the helmet also, was present in the moments after the crash. That leads us to believe that there was an active construction site going on at around the time of the crash. The nature of this case, Your Honor, is not in dispute. The two vehicles collided into each other. We believe one or both of the vehicles was across the lines in an active construction zone by F&F Construction. So I think they've got plenty of notice of the claims. I'm not sure what else they want. We've alleged negligence. We've also alleged that their negligence and failure to follow the traffic control plan, along with their actions on the construction site, were proximate causes of the crash, and therefore the death of Mr. Alonso and plaintiff's injuries and damages that they suffer. So if there's more information that they want, they have the documents, they can look at it, but I think they're on a fair notice of our pleadings and the facts that of our cause of action and the facts that underline them.
Mr. Ordonez, yes.
Just real quickly, there's no fact as to how we caused this accident. Again, it's all conclusory in nature. It's not negligent to be at a construction site, which my clients absolutely deny that they were that day. But still, if they were, that's not negligent. There are no facts to support any sort of way that we caused this accident. Nothing has changed from their 4th amended petition to their 5th amended petition, except now they contain conclusory allegations with no basis in fact.
All right, so I'm a little bit at a disadvantage here because I haven't seen, and I'm not going to, I'm sure you could articulate it fully, Mr. Greenberg, but I want to see the written response. And I don't see it. The clerk is telling me there is not a filing. So please double check that. Mr. Ordonez, I also am not, I know you've responded here, but I'm not going to hold you to that being your full response because as you've indicated, you received it only a few minutes before the hearing. What I am telling you all is this. As soon, Mr. Greenberg, if you'll check on that filing so I can make sure that I see and your pleading. Mr. Ordonez, if you feel that you have anything to add in terms of a response to Mr. Greenberg, please have it filed with the papers of the court by the end of the week. I will make my decision based on those submissions. If you don't have anything else, Mr. Ordonez, if you would provide Ms. Hernandez with a courtesy stand on what you've already filed, there's no difference, that's fine. I will have a response or a decision for you by December 6th.
And Judge, did you just say I needed to file a response or should I email it to somebody also?
If you have a written response, please file it, but file it by Friday.
Will do.
Because I want to be able to look at everything and have a decision for you in 1 week. Okay?
Thank you, Judge.
All righty. Is there anything else for today?
No, you're
Nope.
right. Thank you.
Thank you, everyone, for your time.
Thank you.
Who's next?
3, Judge. In cause number 2021, DCV 2417, Antonio J. Diaz versus El Paso Healthcare Systems, LTD, et al. Announcement of council, please.
Al Melendez on behalf of Mr. Diaz, you're on.
Cynthia Llamas on behalf of Dr. Crosby.
Gary Norton for Las Palmas Medical Center, Your Honor.
And Courtney Parecki here for Jose Rincon, PA.
Judge, if I might.
I actually have so many questions now. Does he have 2 screens or can we have 2 Zoom?
All right. I'm sorry. Someone was talking.
Mr. Norton has an MSJ hearing, and I think he was in the waiting room for it. Gary, you're muted.
Oh, okay.
I think he's talking in the other hearing because he told me he was in the waiting room.
Yeah, Your Honor, I'm actually in with Judge Baca on a motion for summary judgment hearing. That's my motion.
Okay, so we'll come back to you.
If you give me like 10 minutes, I think we'd be okay.
That's fine. Thank you, everyone.
I think Mr. Melendez is also in an MSJ hearing, but I don't know which one or which court.
No, I apologize. No, I'm in a deposition, but that's not an issue. Whenever we're accommodating in that way, but whenever you guys are ready.
Okay, well, I just assume wait for Mr. Norton. I see we have a motion for continuance and a final status. Was it an agreed motion for continuance?
It is, Your Honor, and I apologize. I didn't email it to you until this morning, about 15 minutes before the hearing started, before my hearing was scheduled. But it is an agreed motion, and we can come back to it, or I can summarize it, but I think we should come back to it.
Okay, then I will look for it and we will come back to you all. No, I don't see that. All right, who's next?
Page 5, Judge.
Give me 1 sec. No, I don't see it. Okay, go ahead, page 5.
Yes, Judge. In cause number 2020, DCV 4223, Leticia Isabel Lawrence et al. Versus Tenet Hospitals Limited et al. Announcement of council, please.
Paul Grajeda for the plaintiffs, Your Honor.
Cynthia Llamas for the remaining defendant, HCN EP, doing business as the Hospitals of Providence Northeast Campus.
Status conference. And we still have a specially said jury trial. Okay.
I am pleased to report that we resumed settlement negotiations. We do have depositions that are scheduled. Mr. Grajeda de-designated one expert, so I'm going to cancel that particular deposition, but he still does owe me his primary ER medicine expert's dates for that deposition. but we're progressing, and we resumed negotiations last night.
Okay, great. Well, we have a motion to compel set for December 13th.
I think I'll be able to cancel that one as well. It is during a deposition, and it was regarding the juices tecums for the expert depositions. As soon as I have an opportunity to review the material that was submitted to me yesterday, I think I'll cancel it, and then if it's insufficient, I can come back. That might be the easier way to do it.
Sure, that's fine. We won't do anything until I hear from you all. But then from there, we don't come back until May. So anticipate that if we're not seeing each other in December, that I might stick another status conference either in January or in February, okay?
Sounds good.
Yes, Your Honor.
All righty, thank you very much.
I'll
Okay,
hang out here waiting for Gary.
Thank you, Mr. Grajeda. Have a good day.
thanks, you too, Judge. Bye-bye.
Bye-bye. Who's next?
Judge, I'm not sure we have everybody on page 6, Judge. We do have several, but I think we're missing a couple.
Page 6?
Yes, Judge, and it continues to page 7, 8, and 9, Judge, and 10, Judge.
So I don't know if we have that many. What time is it? It's 10:40.
Yes, Judge.
So let's see, Miss Norvell is here, right? I thought I saw her. Yes, Miss Norvell, Mr. Borshaw. We need Mr. Green or someone from their firm. Mr. Kaufman. Is there a Miss Salinas? Yeah, Mr. Borshaw, were you going to say something?
Yes, Your Honor, I was just going to tell you, Mr. Green's office has been subbed out for new counsel as to those defendants. So I don't think anyone from his office will be here.
Your Honor, Cole Thompson, I'm here for Joanna Salinas.
Okay.
And I think we've got Miguel Talamantes, who's here for Dan Hernandez.
Okay, that's one more.
Good morning, Your Honor. Yes, I'm here.
Okay, why did I did see, I thought they were subbed out only as to certain parties, but he was still on for others. So let's kind of do a roll call then. Who are we missing?
Judge, I show Mr. Vega.
On Miss Zamora, okay. So we want to give them a call.
Ms. Zamora, that one party was entered an appearance, but it was the wrong Ms. Zamora, and the correct Ms. Zamora has never been has never appeared in this case.
Right, that's accurate.
Okay, so Miss Zamora is outstanding. Okay. So who subbed in on behalf of Mr. Green?
Your Honor, I believe that was us.
Mr. Thompson?
Yes.
Okay.
And I represent Faven's Oil Company, the estate of Charles Engel, and Vivian Bean Engel.
All right. Then isn't that everybody?
I think we've got everybody.
Yeah, I don't know if maybe I did see the sub out on Mr. Green. I did see the issue with Miss Zamora, although my note still showed Mr. Vega as having represented correct Miss Zamora. And maybe there were multiple sub outs on these parties because I did have Miss Salinas on, but I didn't have her across the board. Who is with Van Horn Propane Inc. DBA? I had Mr. Kaufman down.
I believe they've been dismissed.
Go ahead, Kim.
Oh, I just said I thought they'd been dismissed.
I think they were. I think that's accurate as well, Your Honor. Okay. There was defendants that had been non-suited in this case, and that's one of them.
Okay. All right, then everybody is here.
Okay. In cause number 2021 DCV 2041, Lizette Vasquez versus Sandra V. Zamora et al. Announcement of counsel, please.
Jeffrey Borshaw for the plaintiff.
Kim Norvell for Valero Marketing and Supply Company.
Miguel Talamantes for I'm sorry, go ahead, Cole.
Cole Thompson for Favens Oil Company, the estate of Charles Engel, and Vivian Bean Engel.
Miguel Talamantes for Leslie, Jean Clemmy, and Clemmy Enterprises, Inc.
Okay, we are scheduled today for motion for summary judgment.
Yes, Your Honor, if I may, late yesterday, we were able to reach an agreement regarding the motion for summary judgment, and my client will be dismissed subsequent to that agreement. And so we will not need to go forward with our hearing on the MSJ for Valero today.
Let's see. I had a feeling. Okay, so yeah, this one was over. Thank you, Ms. Norvell. I'm just trying to catch up on the docket here.
No
So we
worries.
also have a motion to compel and a motion for leave to designate responsible third parties. Okay.
Yes, Your Honor.
Mr. Talamantes?
Yes, those are mine. I'll address the motion for leave to designate responsible third party first. And I'll specifically take the opportunity to address plaintiff's reply, which have to do with the pleading sufficiency, and which is and in this case we've plaintiff alleges a premises defect, basically that there was insufficient space and lack of bollards or protective barriers. This is basically a design premises defect, right? We've alleged that in 1980, and our RTP motion provides that in 1985, the Favens Oil Company contracted with Thomas Construction Company to design and modify the physical layout of the subject gas station. The pleading sufficiency standard does not require much. I believe we've met it. And the second point as to plaintiff's response regarding the timing and the expiration of the statute of limitations. Now, Texas Supreme Court has been clear on this. Defendant is not required to disclose responsible third parties before the Texas Rules of Civil Procedure require it to do so. In this case, the provision cited by plaintiff, which is section 33.004 subsection D, that talks about that a party cannot move to designate a responsible third party when the statute of limitations has expired. It's not an issue here because the statute of limitations expired even before the claiming defendants were served. So that is not a concern here. This thing happened, the event given rise to this lawsuit happened on August 6, 2019. We were sued on August 3rd, 3 days short of the statute of limitations. We were not served until November 17, well after the expiration of limitations. We answered on December 10th of 2021, and our initial disclosures and obligation to disclose responsible third parties was not until January 1st, 2022. Accordingly, that issue regarding the expiration of limitations is simply not at play here because, as the Supreme Court has explained, that section exists to prevent the imbalance in gamesmanship that may occur when a defendant seeks to cut down on its own liability by designating a responsible third party, and plaintiff is precluded by the statute of limitations from seeking recovery from that third party. In this case, the statute of limitations expired due to plaintiff's delay in filing suit, and so that is not a concern. All things aside, the motion otherwise complies with being filed 60 days before trial, and that's why the court should grant our motion for leave to designate these responsible third parties.
All right, Mr. Brushow.
Thank you, Your Honor. Really, the operative question here is whether the disclosure of Thomas Construction was timely. We'll set aside the issue of the pleading requirements, whether it's been pled sufficiently to allege sufficient facts. But I want to focus on timeliness because both of those issues are required under the rules for the defendant to meet in order to designate Thomas Construction as a responsible third party. Plaintiff submits that in this case, the designation of Thomas Construction was not timely under the rules. A precise reading of the rules, and it's very simple, we'll just read the rules, is what's necessary in order to answer that question. The first rule is found in Civil Practice and Remedies Code section 33.004D, which says the following. A defendant may not designate a responsible third party with respect to a claimant's cause of action after the applicable limitations period on the cause of action has expired with respect to the responsible third party if the defendant has failed to comply with its obligations to timely disclose that the person may be designated as a responsible third party under the Texas Rules of Civil Procedure. They have to be timely disclosed under the Texas Rules of Civil Procedure in order for them to be designated as a responsible third party. The timeliness component then to disclose a responsible third party is governed by the TRCP, Texas Rules of Civil Procedure, and specifically Texas Rule of Civil Procedure 194.2 governs the disclosure of responsible third parties and indeed all disclosures. With respect to the time for initial disclosures, Rule 194.2 says, a party must make the initial disclosures within 30 days after the filing of the first answer or general appearance, unless a different time is set by the party's agreement or court order. A party that is first served or otherwise joined after the filing of the first answer or general appearance, which in this case applies to CLEM, must make initial disclosures within 30 days after being served or joined, unless a different time is set by agreement or court order. The CLEMI defendants have moved for leave to designate responsible third parties, one of which is Thomas Construction. And Thomas Construction was disclosed by CLEMI for the first time as a potential responsible third party on October 10th, 2023, just last month. We filed an objection to that motion, citing Civil Practice and Remedies Code 33.004D, which says that they may not do so after the applicable limitations period has expired if they have failed to timely disclose the responsible third party under the Rules of Civil Procedure, which by a clear reading of the rules they have not, and I will explain how they have not. CLEM filed a reply to our response to our objection in this case, stating that their disclosure of Thomas Construction, which again was first made on October 10th, 2023, in what was called their first supplemental initial disclosures, was timely because it was made more than 60 days before trial. That is one of the components under Civil Practice and Remedies Code 33.004. And because they were served with process and appeared in this lawsuit after the limitations period had expired, and therefore there was no gamesmanship on their part. Essentially, they're making a no harm, no foul argument. However, they're glossing over the precise wording of Civil Practice and Remedies Code 33.004, which we already went over. In this case, CLEMI's pointing out in its reply on page 2 that plaintiff did not serve the CLEMI defendants until November 17th, 2021, which was more than 3 months after the statute of limitations has already expired. They then filed their answer on December 10th, 2021, and accordingly, that their required disclosures and first opportunity to identify potential responsible third parties was not due until January 10th, 2022, more than 5 months after the limitations period expired. Now, while their computation of their deadline to serve initial disclosures, including the disclosure of responsible third parties, is actually incorrect, because their deadline was actually December 17th, 2021, 30 days after they were served, because there had already been an answer filed by another defendant in this case. They were still nowhere close to timely disclosing Thomas Construction or anyone else for that matter as a responsible third party. CLEMI says in its reply brief that its deadline to serve initial disclosures was January 10th, 2022. I think that's incorrect, but even if we go with that deadline, they're still woefully late in disclosing responsible third parties. If their deadline, as they've argued, was January 10th, 2022 to disclose responsible third parties, Did they disclose Thomas Construction as a responsible third party on January 10th, 2022? No. Did Clemmy disclose anybody as a responsible third party on January 10th, 2022? No. Did they disclose anything on January 10th, 2022? No, they did not. They didn't serve their initial disclosures by that deadline. Despite the fact that their mandatory disclosures were due on January 10th, 2022, according to them, they didn't serve any disclosures in this case whatsoever until May 26, 2023, nearly a year and a half after their initial disclosures were due. On that date, May 26, 2023, Clemmy produced documents with their initial disclosures that they said they retrieved from the city of El Paso through a portal with the city, along with their other disclosures, which, according to them, those documents gave rise to this motion that they're arguing here today. Those documents appear to indicate that Thomas Construction was a contractor at the subject property where this incident took place that pulled a building permit in 1985. Yet, even having these documents in their possession, Clemmy did not disclose Thomas Construction as a responsible third party when they served their initial disclosures on May 26, 2023. It wasn't until an additional 5 months had passed when Clemmy finally disclosed Thomas Construction as a responsible third party when they supplemented their initial disclosures on October 10th, 2023, just last month. 33.004D, again, it says that the defendant may not designate a responsible third party if the defendant has failed to comply with its obligations to timely disclose that person may be designated as a responsible third party under the rules of civil procedure. I've already recited that rule for the court. Clemmy's also argued in its reply brief that they did not retrieve these documents from the city of El Paso where they learned about Thomas Construction and their potential connection with the case. They didn't retrieve those documents until after the applicable limitations period had passed. While that doesn't matter under a precise reading of the rules that we've already recited, when those documents were actually retrieved by Clemmy is unknown. I don't know when they actually got those. Now, what we do know is that those documents that were produced to us on May 26, 2023, those documents from the city of El Paso bear a date and time stamp on them. And the date stamp on those documents is October 19th and October 20th, 2022. So I don't know when Clemmy actually got those. What is known is that Clemmy produced those documents to us for the first time on May 26, 2023, which was 7 months after the date stamp on those documents. And even then, Clemmy still waited until October 10th, 2023, an additional 5 months later, to supplement their disclosures and for the first time disclose the name of Thomas Construction as a responsible third party. With respect to the timeliness of supplementation, the Texas Rules of Civil Procedure tell us what that is too. Rule 193.5 says that with respect to supplementation of discovery responses, an amended or supplemental response must be made reasonably promptly after the party discovers the necessity for such a response. The documents produced by Clem on May 26, 2023, which are date stamped Clemmy 35 through Clemmy 119, and which are referred to in their disclosures as documents received from the city of El Paso, have date stamps on them from October of 2022. So it raises the question of whether those documents were actually in the possession of Clemmy from October of 2022. If so, they possess those documents, which have a reference to Thomas Construction in October of 2022, but those documents were not produced until May of 2023, when initial disclosures were first served on us a year and a half they were actually due in the first place. And Thomas Construction was not disclosed until October of 2023. In summary, Your Honor, a disclosure of Thomas Construction on this timeline with these facts can hardly be deemed timely under the Texas Rules of Civil Procedure. And that's exactly what Civil Practice and Remedies Code 33.004D says cannot happen if a defendant wishes to designate someone as a responsible third party. So with that, the plaintiff stands on her objection to Clemmy's motion for leave to designate Thomas Construction as a responsible third party, and we ask the court to deny that motion to designate Thomas Construction as a responsible third party in this case.
Mr. Talamantes, do you have anything else? You're muted. I may have muted you because there was a little bit of background noise. It's hard to hear.
Oh, thank you. No, I don't know if it may have been me. Yes, just two things. One, I'm not sure why these documents were not produced earlier, or this designation prior to last month. But whatever, I mean, what is at issue here is not whether the designation and the production of the documents was timely. That is not an issue right now. We are looking at specifically at whether section 33.004D applies or not. And the Supreme Court has been clear, and I quote, placing the onus on a defendant to respond before the Texas Rule of Civil Procedure obligated to, I'm sorry, let me back up. Placing the onus on a defendant to respond before the Texas Rules of Civil Procedure obligated to do so not only contravene section 33.004 express language, but would also be unfairly prejudicial to defendants. This is In Re Mobile Mini Inc. 596 Southwestern 3rd Series 781 Texas 2020. Back to my point, it's so the main, yes, Mr. Barshall has made that section 33.004D is clear, and I agree with him in that. But the Supreme Court has interpreted that section and says that in cases such as this, where a defendant's obligations to disclose responsible third parties does not kick in until the statute of limitations has expired, then section 33.004D is inapplicable. That would be all, Your Honor.
Mr. Borshaw, do you have anything else on that point?
Nothing further, Your Honor, just except that the reading of the rule is clear, and we don't believe that the disclosure is timely, and we are so far along in this case now, and because it was so dilatory, more than a year and a half in litigation before this name was disclosed, it clearly doesn't line up or meet the standard under the rule.
Your Honor, if I may just add one last small comment.
Yes, sir.
As Mr. Barshall currently stated, the basis of this designations are public city records. Yes, that we may have been timely producing, but at the end, this is not something that we were hitting, and this was equally accessible to plaintiff. So any concern that we could have or may have been untimely in producing these records or disclosing this potential responsible third parties, this was something that was equally accessible to plaintiff, but also the plaintiff maybe also should have looked at when he was filing her petition. That's
and Your Honor, just one last thing in response to that. The records may be equally accessible to us, but it's not the responsibility of the plaintiff, and it's not our motion here to designate a responsible third party. It's defendant Clemmy's responsibility to prove under the rules that they were timely in their disclosure, because they're the ones seeking to designate Thomas Construction as a responsible third party, not ourselves.
All right, gentlemen, thank you very much. The request or defendant's motion is respectfully denied. We can go on to the motion to compel if that's still an issue.
I don't know if it's an issue for Mr. Talamantes. I will say, and if he's conferred with his associate with Dan Hernandez, I spoke to Dan Hernandez about this motion after it was filed, because we do the subject expert report. When I spoke to Dan, I told him we need our expert to inspect the site at this gas station where the incident occurred, and we are attempting to isolate dates on which that inspection can take place, because certainly after the inspection is done, the expert report will be prepared and submitted to all counsel for the defense. I did, just to update the court, I did just speak to our expert this week, and he's given me several dates in January of 2024 on which that inspection can take place. And so I will circulate those dates to Mr. Hernandez and every other counsel for all the other defendants so that we can get that inspection lined up, get the expert report done, and it shouldn't be an issue. But if Mr. Talamantes has something else he'd like to inform the court of with respect to that expert report, he's free
Mr.
to do so.
Talamantes, are you asking to go forward on the motion to compel today, or do you want to hold that for a later date based on like, what discussions are happening in terms of scheduling?
Well, I would definitely want something set in an order, because we have waiting for dates since since October 10th, when I informed Mr. Barshow to give us dates for this inspection. So that's almost 2 months ago. And we have yet to receive an actual date. We have told Mr. Barshow that we are happy to accommodate his expert whenever he has time, but it's almost 2 months and he has yet to provide a date. That would be yes, he's claimed that he needs the inspection to take place, but as I said, we've received no dates for the inspection. We would also accordingly, since we have no report that our expert, since we don't have a report that any potential expert of our own could review to prepare a counter report, we would also ask the court to extend our deadline for the report, because Mr. Barshow's deadline was 20 days, almost 20 days ago, November 10th. And we're expected to present one in 20 days. Well, a little bit over 20 days. It's December 20 for defendants, but we are unable to meet that deadline since we don't have an inspection, much less of a report. So we're happy to work with Mr. Barshow, but we would definitely want some somewhat fixed deadlines or maximum range, and also an extension of our deadline to present our expert report.
Dates? Sorry, Mr. Talamantes, what are the dates you all are looking at?
Yes, and you're reading my mind, Your Honor. I was actually going to go ahead and state on the record, so the dates that I have from our expert that he can come down for his inspection are the week of January 15th through the 19th, that whole week, January 22nd and January 23rd. I've also checked those with my colleague, with Maled Farah, because I am likely to be out on paternity leave. I'm expecting my first child here pretty soon. But Mr. Farah is good with those dates. And so I was going to circulate those to everybody else. And hopefully one of those 7 days should work for everybody. But those are the dates that I can state on the record right now. And also with respect to the deadlines, we're certainly able to work with counsel by agreement and extend those deadlines if necessary. I think we talked about this over email a few weeks back, because we noticed there was I believe, and maybe Kim can weigh in on this. I think there was an error in our scheduling order, that maybe it was a typo or something that listed an incorrect year, and so we've already agreed to extend the deadlines if necessary, and I'm sure we'll be able to do that by agreement.
Okay. So, Mr. Talamantes, I did hear you are asking for some type of time certain meeting, some type of deadline by which to have the inspection scheduled, correct?
Right, yes, well, and I think, I was able to jot down the first one, January 15th through 19th. I will need the, yes, I would want to lock in the inspection as well, as maybe the report in our.
Mr. Talamantes, what we're going to do is I'm going to grant the motion to compel, and for there to be a deadline of 60 days. So that puts us at January 31st, 2024. Obviously, with all of these different dates up in the air and deadlines, that it sounds like you all should be able to work together to manage any agreements you all make. Obviously, you can do that, but in terms of, sounds like we have a good set of dates to keep things on track. The motion is granted. with that deadline. If you all agree outside of that, so for example, Mr. Talamantes, Mr. Borschow, it turns out because of scheduling, that inspection doesn't happen until February, whatever, 4th, as long as it's done by agreement, that's fine by the court.
Your Honor, if I may, just to shed some light on what I was just speaking about, and it fits in with what you were just saying. It was on November 6th of this year, so about 3 weeks ago. I emailed all counsel and I attached the scheduling order, and I said, in review of this scheduling order, I see that we made a mistake as far as the deadlines for filing and serving expert designation lists and expert reports. And it was my error because I was the one that wrote in the dates by hand. The deadline on the order for plaintiffs' expert reports was November 10th, 2024. That's the way it was written. And obviously that's a mistake because trial is in August of 2024. And the deadline for the defendants was listed as December 20th, 2024. And I think it was meant to be 2023 on those, but because of the confusion it caused, I emailed everyone and I asked if everyone was in agreement to establish the deadline for plaintiff to February 6th and for defendants to March 6th, which would seem to fit in with what we're doing right now. And so
are you telling me that if there's an agreement there, we don't really need a motion to compel?
It's not my motion, Your Honor. I would defer to Mr. Talamantes on that. I did send that email and
okay.
And I'll cut in, yes, Your Honor, we can forgo the order as long as we have an agreement on the record that those will be the deadlines.
So then there is no disposition on the motion to compel. If at some point, Mr. Talamantes, I'm hearing there's an agreement. If at some point you need to re-urge for whatever reason after you've agreed to some deadlines, please readdress it with the court. We'll set you for a hearing. Okay?
Thank you, Your Honor.
All right. What else? That's all I had on my docket. But
nothing further from the plaintiff, Your Honor.
All right, Mr. Thompson, Ms. Norvell.
Nothing further on behalf
of call. All right.
Nothing, Your Honor.
Thank you very much. Good luck to y'all. Take care.
Thank you.
Thank you, Judge.
Who's next?
Judge, back on top of page 2, Judge.
Yes.
In cause number 2022 DCV 0042, Maria del Carmen Gonzalez versus Irma Alicia EM. Announcement on the council, please.
Bobby Ramos on behalf of plaintiff Carmen Gonzalez.
Sergio Mendez on behalf of the defendant, covering for Sean White.
So I had, if I'm not mistaken, let's see, we got docket call, motion for continuance. My notation says you all are looking for 160 days reset. Is that correct?
Yeah, that's correct, Your Honor. We're working on still getting some medical records that we can provide so that we can go ahead and schedule the plaintiff's deposition as well as the defendant's deposition. And also we're wanting to try to mediate this before we have to take any more of the court's time.
Yeah, I think this is one. There were 2 different faces here last time, I think, and the court was not inclined because I think this has been reset a whole bunch. But we're super busy and I don't mind giving you all 160 days.
Your Honor, if I may.
Yes, sir.
Actually, I was thinking maybe we could get more time since we have to mediate and schedule depositions if we're able to.
Let me, before I absolutely shoot you down on that one, let me go back and make sure I'm not misspeaking about this case. Yeah, we've had, let's see, one, 2. This is the 3rd trial setting. but they all appear. They all appear to just be in 2023. I don't know why you're scheduling conference. Your initial one went a year without there being another scheduling order. All right. How much time, Mr. Mendez?
We were thinking maybe about 6-7 months, if possible. We've been trying to get some documents since January from the plaintiff, but we haven't been able to get those documents, and we would like to have them before we prepare for trial and mediation in this case.
Okay, so I'll give you until September. September 27th will be your new trial date. In fact, let's just do a whole new scheduling order. So we'll get you a scheduling order. Use that trial date, set your mediator, put your mediator on there. I'm not going to delve too deep into anything that has been done before. All right, we'll use that date.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you for your time. Who's next?
Back to page 3, Judge. In cause number 2021, DCV 2417, Antonio J. Diaz versus El Paso Healthcare System Ltd. Announcement of counsel, please.
Al Melendez on behalf of Antonio Diaz, Your Honor.
Gary Norton for Las Palmas Medical Center, Your Honor.
Cynthia Llamas for Dr. Crosby.
And Courtney Parecki for Jose Rincon, PA.
All right. Motion for continuance, final status. Everybody's back. Everybody's free. Mr. Norton, you're busy.
I apologize to everybody, Judge, for my...
No worries. As long as everybody's good to go. What are we doing, folks?
Your Honor.
Let's see. Go ahead, Cynthia.
Your Honor, I just re-emailed you. I mean, when you said you hadn't seen the motion, I re-emailed it just to you, not just the coordinator. The primary reason for the continuance, Your Honor, is sadly, Mr. Rincon's attorney passed away in May. Russ fell, and the parties had agreed to an extension of, postponing discovery, getting everything, until their firm had reassigned his cases and dealt with the consequences of his demise. Mr. Robert Dry, for whom I believe Ms. Parecki is appearing today, entered his appearance on behalf of Mr. Rincon on September 22nd. And we filed this joint motion for continuance shortly thereafter. I think it was October 4th or so, just to let Your Honor know that we had, due to the demise, we had postponed discovery and deadlines, and we just need to restart discovery. We weren't able to do so while Mr. Shell wasn't here with us. So that's the main reason for the continuance. I don't know if Ms. Parecki or Mr. Norton or Mr. Melendez have more to add.
There, just one more thing, and let me ask for your Honor's guidance on this. There's a motion for summary judgment pending, and the core of it involves a physician-patient relationship between the ER patient, my client, and then the attending ER physician. And right now there's an appeal. So we agreed there was a very similar fact pattern which involves the same core of the relationship in the 41st. And the court denied the summary judgment, but we wanted to.
Everybody's shaking their head, Mr. Melendez.
It was in the 346, Judge.
346.
Okay.
So I said the 41st. You're right. I get confused.
Right. Well, that's
I was just there, so I was familiar with that name. Yeah.
So that right now there's the court went ahead and heard the case on submission only just recently. And so we're waiting for an opinion that may provide some guidance to the court. Maybe we can even agree to postpone the summary judgment pending that possible decision. Maybe it should hear it because it has the same core fact pattern of why Ms. Llamas doesn't think there was a physician-patient relationship.
So you're telling me to wait on the Court of Appeals? Is that what you're
telling me?
No,
not necessarily, but I was just throwing that in there. That's for that guidance. I mean,
well, maybe our scheduling, based on what you're telling me, might align, right? So what are you all asking for, because I have you specially set and it's a 2021 case in February. So that's out. I'm hearing that's out the window, right?
Yes, Your Honor. I think we're probably late summer would probably be my guess, maybe August, just to give us some time.
Yeah, I'm happy to put you down thereabouts, probably maybe even October. I'm not so sure about August. In which case, it sounds like you're telling me you want to hold at least the summary judgment off until the Court of Appeals maybe. No, Ms. Llamas? Talk to me.
No. I understand what Mr. Melendez is saying. However, my no evidence motion for summary judgment, although it does focus on the issue of no physician-patient relationship, is a complete no evidence motion for summary judgment on the entire claim.
Okay.
So, and I filed it because I needed to do so in accordance with the court's scheduling order in a previous case that I had before Your Honor with Mr. Grajeda. As a matter of fact, I had an agreement with plaintiff not to do that, and Your Honor didn't seem too happy that we were not following your deadlines, and we were agreeing to sort of be nice and not follow those motions. So I did file a no evidence motion for summary judgment. I would respectfully ask that we keep that setting. It's set for January, I believe. If the and let's just pick up. I can speak with Mr. Melendez. We can pick up at the beginning of next year whether I can agree to postpone it or not, depending on what the Court of Appeals has done and also what my clients are asking me to do.
Okay. I'm happy to do that. In fact, use that January 10th date as a full reconvene with the understanding that that trial setting is going to be continued, but we're pending, I guess, some of the details on that. So why don't we reconvene? Motion for continuance of the trial setting is granted. So we still have our January 10th final civil pretrial and summary judgment hearing. And we'll go from there.
And we'll pick a new date at that time, Judge?
Yeah, we'll pick a new date at that time, but I think it's going to be the same. I mean, we're looking at the same timetable.
Okay, that's fine.
If things get more complicated for some reason and you need something different, we should still be able to accommodate almost anything there.
All right. Your Honor, our agreed order vacated that final civil pretrial conference. So if you would like, I'll just take that out. Get that order approved by all counsel and resend that to you separately, or do I do it to the
That's perfect. Yeah, to the court coordinator is fine, and then she'll get it to me. Please.
And so, just so I can understand our thinking, so we're gonna do a new DCO with new deadlines as well, correct?
If that's what you all are agreeing to, yes.
I think that's what we need to do in light of a new trial setting, Judge, because of where we are in the discovery.
Yeah.
Okay. If you all want to circulate that, and just have it ready for that January 10th setting. Okay.
Thank you, Judge.
In which case we use the same date, right? Did I give a date? I'm losing track.
No,
here.
ma'am, you did not.
Oh, okay.
That's why I was asking if we were going to wait and do it on the 10th.
Okay.
Because you did not give us a date.
So let's do October 18th. October 18th.
All right.
Just tell me, Mr. Norton. Just tell me. We need a date, Judge. I'll do it.
I've stopped trying to read minds, Judge. I'm wrong too often.
Me either.
I'll circulate. Yeah, and I'll circulate an agreed order regarding the continuance of the present setting, but keeping the final civil pretrial conference date of January 10th.
Sounds good.
I've been married 32 years, Judge, so I know that I can't read minds. I've been convinced by
All right. Thank you very much, counsel. Ms. Parecki, do you have anything for the court?
No, not at this time. Thank you, Your Honor.
Okay, we'll see you all in January. Take care.
Thank you.
Thank you.
Thank you, Your Honor.
Bye.
Thank you, Judge.
Bye-bye. Okay, next.
Bottom of page 11, Judge. In cause number 2023 DCV 2094, Eric Segura versus Assam Fadi et al. Announcement of counsel, please.
Good morning, Judge Bruce Gomez for Eric Segura.
Good morning.
Good morning, Your Honor. Joseph Vasquez, representing Fadi Azam.
So we have a scheduling status conference, but the notation here is you're just requesting a bench trial. Is that right?
We're going to attempt to mediate, Judge, but yes, bench trial. That way we get rid of this case one way or another.
Okay. So let's see. I'm not really, if you all aren't asking, sorry, it's coming up. If you all are not asking for, you know, a scheduling order and all of that kind of thing right now, what I would like to do is have then an order with a deadline to mediate. And then I think I may wait because I think we should be okay in scheduling a bench trial until we know what happens. So do you need 60 or 90 days?
I say 60. Well, you know what? I changed my mind. I say 90 only because mediators are booked.
And the holidays are going to be crazy. I'm happy to give you all 90 days. 90 days. I will add a status conference in January, January 17th at 11 a.m. just to check in with you all if scheduling is really a problem and it looks like we're not going to get it scheduled within the 90 days or something else comes up, I'll check in with you then. But those would be the only two things.
Cool deal, Judge. Thank you. And I'll be sending some informal offers to Mr. Vasquez, see if we can get a result.
Okay. Myrna, would you also have a scheduling status conference, not only on that January date, but something that coincides with the mediation deadline? Okay. So the first Wednesday after that mediation deadline. Okay. All righty. Thank you very much.
Sounds good, Judge. Thank you.
Mr. Vasquez, you're going on Friday, right?
Yes, ma'am.
Okay, cool. Thank you.
Okay. Thank
Bye,
you.
Judge.
Bye.